Okay, Deputy Creed.
Chairman, just a few questions in no particular order. Is there any evidence that banks are running ahead of the legislation in terms of efforts to secure judgments against parties who are in financial difficulty, that they see perhaps a game changer ahead, and that if they have some secured judgments against individuals, that may in some way put them in a more advantageous position than they may be in subsequent to legislation being passed? I'm interested in the...
Answer that before we move on to the next point. Yes, Mr. Holohan.
The difference having a judgment would make in an insolvency situation is the interest that would apply to it. Because if you have a judgment debt, it's 8% per annum under the Courts Act. Whereas if you have, say, an interest rate at the moment, which is a tracker mortgage, at maybe 1% above bar, that could be lower than that. So there might be an incentive. But personally, I wouldn't think that there's any great rush to judgments, plural, by banks at the moment.
You speak about raising the threshold from 3 million to 10 million. Now, I can understand there may be circumstances where, a business is involved, and obviously there are consequences in a business for employees and all that. But I suppose the primary objective from most of our experience is securing the family home for people. I mean, reference was made earlier to holiday homes and apartment investments, but the critical thing is the family home, and I suppose it goes back to, the bill by Deputy Donnelly. Is there a case to be made in respect of the legislation to differentiate internally, which isn't there now, that gives absolute protection to the family home?
Just maybe get Mr. Holohan, do you want to come back on that?
The answer to that is yes, but as a rural TD, you'd probably understand yourself. I had an example a couple of weeks ago of a farmer from Wexford and his wife who have borrowings over 12 million. But they are losing a family farm of 4 generations because of what has happened. Now, that's a difficult one to try and legislate for.
Okay. The other one, this is just an observation, I suppose, in the context of the heads of the bill that we've seen. I think it is naive, really, to think that an appeal system that will adjudicate that a bank was unreasonable will be sufficient deterrent for a bank to kind of come to the table with clean hands. I think there has to be consequences, capital consequences for a bank if the legislation is to have real teeth. Because, let's call a spade a spade. The banks have the authority in the legislation as proposed to thwart the intentions of everybody in this regard. And I just think, really, assuming that embarrassment will force them to play ball, I think, from the experience I have of dealing with them, brass neck doesn't go anywhere near describing the audacity that financial institutions treat people with. And I just think certainly that aspect of the proposed legislation needs to be beefed up significantly.
Okay, we'll talk about that when we get to review the report. Mr. Holohan.
I'd say, as one fictional legislator said, you might say that I couldn't possibly comment.
Okay. Deputy Donnelly, you want a few brief, short, focused questions?
Thank you, Chair. Brief and focused, 2 quick questions. Mr. Hall and Mr. Maguire have already outlined the power of adding the essence of the Family Home Protection Bill to the Personal Insolvency Bill. And so what I would like to ask them is just to address, I think, probably the 2 most substantive concerns that Minister Shatter raised, so that the committee has. So if I could, the first one is, the first substantive concern Minister Shatter had was around constitutional compliance, particularly with Article 43, which protects private property. And I wonder, Chair, if I could just get their thoughts on that one first.
Yeah, okay.
The minister raised concerns about a situation where a court could refuse the bank's security on the basis the bank has a property right, and that would be the court interfering in its property rights. And he raised that as a possible constitutional issue. But I know that Deputy Donnelly has taken the advice of senior academics, legal academics and other lawyers, and the very basis of constitutional law is that we do a balancing exercise. On the one hand, you've got the common good, which must always trump any private interest. And all we're saying here is that the common good recognises that for sustainability and for recovery in this country, there has to be a modicum or a a reasonableness on the part of the banks in terms of doing deals. And all we're saying is the court could enforce that. The court itself would, of course, always be required to act constitutionally and in accordance with procedures. It would have to hear what the bank has to say. It would have to weigh up the balance. But the idea that you think that anybody would say that the bank's property interests trump everything else is, in my view, not the law. The law is about balancing.
The General will probably have a view on that as well at some stage, if it goes that far. Deputy General, you have another question?
Thank you, Chair. The second, I think, the second most substantive issue that Minister Shadow raised was his concern that by allowing a judge to include judge's discretion, which would include the potential conduct of the lender. The intention of the bill had been just to a specific case. Minister Shadow was concerned that a standard repossession case in court might become a full-blown tribunal of the banks, much as we might like something like that to happen. He felt it wasn't practical. Could I ask Mr. Maguire, anyone else, if he thinks that would be the case, and if not, why not?
The courts would look at the individual case before it. As we do, when we look at cases, we see underwriting. In other words, the bank lent money at maybe 10 times the person's salary or wages. That was a situation that was bound to end in failure. It couldn't do anything else. So the court could take into account under that legislation, or under, if that was included in here, the type of underwriting that went on, and then taken together with an offer of restructure, say that given your crazy underwriting, there must be consequences to that. This is a reasonable offer of restructure, and in those circumstances, that should be the new deal.
Mr. Holohan, yeah.
Head 81 of the bill sets out the purposes of Part 5, and it talks about various purposes, including providing a fair and balancing between the interests and rights of debtors and those of creditors in connection with personal insolvency arrangements consistent with the principles of social justice and the exigencies of common good. Now, ultimately, it's a valued judgment, but I can suggest in H, which sets out in square brackets any other purpose to be specified, a formula of words that I've put together, having burnt some midnight oil, which takes every single constitutional reference to the common good and balancing of rights, puts it in a formula of words. Will it stand the test of time or the Supreme Court? I don't know. But if you want it, I can let you have subsequently my wording.
Okay, thank you very much. Everyone done? Everyone happy? Okay. I want to thank you very much for, again, coming here today and giving of your time and expertise to help us in our work. And, sorry? Oh, yeah, yeah. So, yeah. If you want to move to the front or to the back, it's up to yourselves. You know. The next groups. All right then.